Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a program stemming from our Curious Lawyer series and is a look at criminal libel laws. We ask, can you go to jail for defamatory speech? What is the history of prison and speech? We will look at a variety of federal and state issues then, from the realm of criminal libel laws to do a deep dive into the First Amendment questions that surround the issue. Lots of cases from the Supreme Court and other state and federal cases. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. So let's start with the legal education issues we are going to address today in this program, libel and First Amendment. We start with criminal libel history. This takes us to the case law. We will start with some cases pre-Republic and at the founding of the Republic to see how libel was seen by the founders as a criminal liability. This, of course, lets us look at the Sedition Act of 1798. We will also look specifically at the federal Supreme Court history, with some oral argument snippets to listen to also. We will further look at state history and some state statutes, and the breakdown ultimately of the states today between those that prohibit libel and those that do not. One fascinating case involves prosecutor Jim Garrison, who you will remember from Oliver Stone's JFK conspiracy movie, and and we will see. A case where before he put Clay Shaw on trial for killing the president, he insulted some local judges and was charged with criminal libel. His case made its way from Louisiana to the Supreme Court. We will also, since we are talking about Garrison, do a fun little sidebar on Garrison and overzealous prosecutions that become weaponized law. This is a case coming out of his JFK conspiracy case. Here are some fun questions we will address today. Can you go to jail for questioning a woman's chastity? Can you go to jail for overstepping libel laws on Craigslist? And of course, we will look at civil libel and the First Amendment with the actual malice requirement that permeates this whole discussion. Framing our whole adventure today is the First Amendment and what role it has played in delimiting criminal libel laws. Let's recall what the First Amendment says. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Before we embark, let's address the issue of whether the First Amendment applies to the states. This is the incorporation doctrine issue. The protections of the first 10 constitutional amendments that had applied only to federal government originally, and not state governments, also apply in most respects to states by way of the 14th Amendment's adoption and its due process clause that incorporates those amendments and makes them also applicable to state governments. The basic test is as follows. Fundamental rights rooted in the tradition and conscience of our people, and thus implicit in the concept of ordered liberty, are applied to states via 14th Amendment. This was the Griswold decision at 381 U.S. at page 499. All except a couple of issues have been applied. All of First Amendment has been incorporated and applied to states. This comes from Gitlow v. New York from 1925. This was one of the first incorporation cases and applied free speech and assembly to states coming out of a case where someone was prosecuted in state court for publishing a left-wing manifesto. So the First Amendment stands against states, and this means we look at a variety of state criminal libel laws that then touch our analysis. Let's take a quick look at this case. State v. Gruber, Maryland, 1819. This is not criminal libel, but it is a close cousin of it. Reverend Gruber preached a sermon at a camp meeting organized by the Methodist Episcopal Church to 5,000 white people and around 400 slaves. Gruber criticized slavery as a national sin and contrary to the founding principles. Gruber was arrested and in a criminal indictment charged with attempting to stir up acts of mutiny and rebellion. Taney, later a Supreme Court justice, defended Gruber and secured an acquittal on free speech basis. Southern states thereafter began passing laws banning abolitionist literature and speech. Of course, as Chief Justice many years later, Taney delivered the Supreme Court's infamous decision in Dred Scott v. Sanford in 1857. What is criminal libel? Libel today is primarily a civil claim brought by someone who feels they are the victim of oral or written slander, but historically it was also a criminal offense prosecuted by the government. Libel as a criminal offense traces its way back to the common law of England in the 15th century, with the notorious English Star Chamber that served as a forum for criminal prosecutions of critics of the king. As the law developed, it branched out and became a civil claim also. The reason for this was written in De Libellis Famosus in 1609. It said, quote, "Libels, regardless of what actual damage results to the reputation of the defamed, may be penalized by the state because they tend to create breaches of the peace when the defamed or his friends undertake to revenge themselves on the defamer." End quote. Thus, sedition and libel was part of the common law of England that was adopted by the American colonies and was enforced in pre-Republic America. Let's stay in our pre-Republic era and look at some criminal libel cases from this time period. In 1735, there was a prosecution of John Peter Zenger. Zenger was a newspaper printer, and he criticized the New York colonial governor in his magazine. Seditious libel was defined as the intentional publication, without lawful excuse or justification, of written blame of any public man or of the law, or any institution established by the law. So the governor started a criminal prosecution and arrested Zenger, who could not afford bail and so was imprisoned. The judge instructed the jury that truth of the utterance was irrelevant to the question of criminal libel. But Zenger's lawyer was able to convince the jury to ignore that instruction with his argument. It was, quote, "The question before the court and you, gentlemen of the jury, is not of small or private concern. It is not the cause of one poor printer, nor of New York alone, which you are now trying. No, it may in its consequence affect every free man that lives under a British government on the main of America. It is the best cause. It is the cause of liberty." End quote. This idea formed this case, then starts sitting beneath our very First Amendment ideas later adopted. This brings us to the Federal Sedition Act. Now, not long after the Republic was formed, the famed Sedition Act of 1798 was inactive. This imposed criminal liability on people who engaged in defamation against the country or government officials. Now, it was highly controversial at the time, and pitted the Federalists and Anti-Federalists against each other heavily. The Sedition Act made it a crime for American citizens to, quote, "print, utter, or publish any false, scandalous, and malicious writing about the government." There was a 5-year prison term and a $5,000 fine. And that number must have been monstrous back then, 250 years ago. It's a lot today if you ask me after all. This brings us to the case of Benjamin Franklin Bache's Aurora Daily Advertiser newspaper. The newspaper was created by the grandson of Benjamin Franklin as a Republican newspaper to challenge the Federalist newspapers. The newspaper was critical of Washington and Adams' presidential administrations, and the Federalists accused Bache of being an agent of the French government. Bache was indicted for seditious libel for his publications related to President Adams. He died pre-trial, so we do not have a definitive answer to the validity of the prosecution. Wow, just pause on that, by the way. Benjamin Franklin's grandson was indicted for criminal libel. The founders didn't mess around clearly. But there were other Sedition Act prosecutions. Today, we understand the Sedition Act to be unconstitutional in light of the First Amendment, but at the time, courts rejected those arguments. Thomas Jefferson in 1801 allowed the Sedition Act to expire, and he pardoned all people who had been convicted under the act in the intervening years. Those convicted also received their fines back. Remember those heavy $5,000 punishments. As the Supreme Court wrote in the Sullivan case we will see shortly, Thomas Jefferson said, quote, "I discharged every person under punishment or prosecution under the sedition law because I considered, and now consider, that law to be a nullity, as absolute and as palpable as if Congress had ordered us to fall down and worship a golden image." End quote. It is also important to note, as you see here from the court, that although the Sedition Act was never tested in the Supreme Court, the attack upon its validity has carried the day in the court of history and public opinion. Let us now turn to some early post-Republic state cases, not under the Federal Sedition Act. These are state criminal prosecutions of libel. We can look at the case of People v. Croswell, reported at 3 Johns Cases 337 from New York in 1804. Here are the facts. The Wasp was a Federalist newspaper published in New York by Harry Croswell. It published a story that asserted that President Jefferson had paid publisher James Callender to run negative stories against political opponents. NY State AG indicted Croswell for criminal libel. The defense tried to put on evidence that the publication was actually true and so could not be libelous. But the judge instructed the jury only to consider whether the statements had been published. This is a huge fault line in the criminal libel case law. Can one assert truth as a defense? Sadly, the jury found him guilty. But he had a great lawyer, none other than Founding Father Alexander Hamilton, who has had, of course, a modern newfound glory from the famed musical of his namesake. So Alexander Hamilton took an appeal for the defendant and made a 6-hour argument for freedom of the press. Courts sure did give people time back then. These days you are lucky to have 10 minutes. But the court split two with two judges writing to overturn the conviction on the basis that truth has to be a defense. The prosecutor did not enforce the verdict as a result, and this showed an early test case that really questioned the viability of criminal libel. We are going to pause and pivot to the broader idea of imprisoning people for speech, even outside the strict libel context. Here I will give you this shameless plug for my book pictured here about the persecution by prosecution trials in the Cold War against labor leader Harry Bridges. In the book, I detail how after Harry Bridges had been ordered deported and potentially to jail for alleged criminal perjury when he swore his citizenship oath, he was then engaged in running the large ILBU union, and he spoke out against the Korean War. But the United States government sought to have him imprisoned for his speech. Claiming as a labor leader, his speech was menacing and could damage the war effort. He argued the First Amendment protected him, but the judge disagreed and ordered him to jail. An emergency appeal to the Ninth Circuit saved him, where the Ninth Circuit stood firm by the First Amendment. Here is what the Ninth Circuit said. Legal ideas that cut back to our ideas sitting beneath jail for speech in criminal libel law. The whole matter appears finally to boil down to the contention that Bridges is a proven communist in that he was found guilty of perjury for swearing the contrary in his naturalization proceeding, and that the subsequent development of the Korean crisis renders him per se a menace to the public security. Hence, the district court was right in revoking his bail and ordering him confined. The conclusion, if we may so, is as startling as it is novel. There was a period in English history when high judges prostituted themselves to the role of mere instruments for carrying into effect the arbitrary will of the crown, and the memory of that experience took deep lodgment in the hearts of the English-speaking peoples. It was in part owing to those unhappy experiences that, in our constitutional system, the judiciary was set up as an equal branch of the government, independent both of the executive and the legislative arms. The conception of the founders was of an unfettered judiciary standing, wherever necessary, between the individual and the exercise by the state of arbitrary power. The Ninth Circuit continued, quote, "It seems to be believed that in this instance the end justifies the means. Perhaps we may be pardoned for doubting whether, even as a practical matter, the end sought will be furthered by the means here employed at the behest of the Department of Justice. A Bridges singled out and jailed by arbitrary judicial action while he is prosecuting with diligence, his good faith appeal poses, to our minds, a more serious menace to the nation and its institutions than does a Bridges enlarged on bail, in accordance with established rules of law and the decisions and practice of the courts. In the eyes of large number of well-meaning and loyal people, without as well as within the ranks of organized labor, even including many of Bridges' fellow unionists who have heartily disagreed with his policies, he will appear a victim of judicial tyranny. An authentic material for propaganda is supplied for the use of the vociferous critics and implacable foes of our democratic way of life. That exact idea then brings us back to arbitrary laws as they intersect with criminal libel, and the need for the Supreme Court to fence the crime into something manageable that does not trigger fears of arbitrary and weaponized legal system afoot. Which lets us get back to our tracing of the criminal libel law. This then brings us to the U.S. Supreme Court in the 20th century now, and we will start tracing the cases through a few decades from the 1930s to the 1960s, which will get us to the modern state of criminal libel law and the likelihood of jail for speech. The journey as we trace these cases that have touched the criminal libel laws is one that gets to the heart of the First Amendment and arbitrary laws that imprison people, and how to manage the risk of imprisonment against the First Amendment freedom of speech and vague laws. When we are done tracing the cases, you will see how the dust has settled as laws stand today in terms of the narrow realm in which criminal libel can stand. But until then, we will start with Near v. Minnesota from 1931. This is reported at 237 United States reports at page 697. There, a Minnesota statute declared that one who engages in the business of regularly and customarily producing, publishing a malicious, scandalous, and defamatory newspaper, magazine, or other periodical is guilty of a nuisance and authorizes suits in the name of the state. in which such periodicals may be abated and their publishers enjoined from future violations. In such a suit, malice may be inferred from the fact of publication. The facts were as follows. County Attorney of Hennepin County brought an action to enjoin the publication of what was described as a malicious, scandalous, and defamatory newspaper, magazine, and periodical known as the Saturday Press, published by the defendants in Minneapolis. Basic charge was that newspaper articles wrote that a gangster was in control of gambling, bootlegging, and racketeering in Minneapolis, and that law enforcing officers and agencies were not energetically performing their duties. Government agents were accused of complicit behavior and dereliction of duty. An injunction followed for the speech. The Supreme Court held the law unconstitutional as a prior restraint. But here is what it said about criminal libel that is important. The law of criminal libel rests upon that secure foundation which was not abolished by the protection extended in our constitutions. This is important because it makes the case that criminal libel is not antithetical to the First Amendment, even if this case required vacating the injunction on prior restraint grounds. Let's now go to the next decade, the 1940s. This is Cantwell versus Connecticut from 1940. This is reported at 310 United States Reports at page 296. Here are the key facts. Defendants were Jehovah's Witnesses and were proselytizing in a Catholic neighborhood. 2 pedestrians got angry at the perceived anti-Catholic message. Defendants were arrested and charged with, firstly, a violation of a Connecticut statute requiring solicitors to obtain a certificate before soliciting funds from the public, and secondly, for inciting a common law breach of the peace. Here is a key noted point, again echoed by the court. Resort to epithets or personal abuse is not in any proper sense communication of information or opinion safeguarded by the Constitution, and its punishment as a criminal act would raise no question under that instrument. Like the prior case, this prosecution fell, even though the court said criminal libel is okay. This time the court rejected this prosecution because protected religious speech is not subject to criminal punishment, and thus even an offensive message is protected where no bodily harm is threatened. Criminal libel is not going to exist here. So we can already see a bit of a trend. On the one hand, criminal libel and jail for speech is okay within the Constitution. But on the other hand, the cases the court gets don't fit the bill for a variety of reasons. Let's go to the 1950s now. This is Beauharnais versus Illinois, and I apologize if I pronounced that wrong. The citation is 343 U.S. 250, and it is a 1952 decision. Here are the facts. Petitioner was convicted in a state court for distributing on the streets of Chicago anti-Negro leaflets in violation of Illinois laws, which makes it a crime to exhibit in any public place any publication which portrays depravity, criminality, unchastity, or lack of virtue of a class of citizens, of any race, color, creed, or religion, which exposes the citizens of any race, color, creed, or religion to contempt, derision, or obloquy. He was fined $200. Herr made constitutional challenges to his conviction, but the Illinois Supreme Court rejected them. This brought him to the Supreme Court. And again, the High Court says, libel of an individual was a common law crime, and thus criminal in the colonies. Indeed, at common law, truth or good motives was no defense. In the first decades after the adoption of the Constitution, this was changed by judicial decision, statute, or constitution in most states. But nowhere was there any suggestion that the crime of libel be abolished. As applied, the court held in a very close split 5-4 decision as follows. The speech amounted to libel and was therefore beyond constitutional protection. Given the racial tensions, the court deemed the speech provocative. That is, the speech consisted of extreme racial and religious propaganda that was distributed to the public and was intended to have a strong emotional effect, so it properly fell within the ambit of the law and was not constitutionally protected. Thus, by a mere 1-vote majority, we see the Supreme Court this time upholding a criminal libel conviction. Now there was a vehement dissent, and not surprisingly, it was written by Justice Black, who of course is a famed absolutist on the First Amendment. He said, "This case is here because Illinois inflicted criminal punishment on him for causing the distribution of leaflets in the city of Chicago. The conviction rests on the leaflet's contents, not on the time, manner, or place of distribution. He is head of an organization that opposes amalgamation and favors segregation of white and colored people." Quote, "This limited scope of the law of criminal libel is of no small importance. It has confined state punishment of speech and expression to the narrowest of areas, involving nothing more than purely private feuds. Every expansion of the law of criminal libel, so as to punish discussions of matters of public concern, means a corresponding invasion of the area dedicated to free expression by the First Amendment." End quote. And still further, Justice Black wrote, quote, "Prior efforts to expand the scope of criminal libel beyond its traditional boundaries have not usually met with widespread popular acclaim. Seditious libel was such an expansion, and it did have its day, particularly in the English Court of Star Chamber. But the First Amendment repudiated seditious libel for this country." End quote. You can see then that the fault line on criminal libel and jail for speech is exposed. And First Amendment fans feel that criminal punishment for matters of public concern should be outside the realm of the First Amendment. But that was the minority position, of course. We are now going to look at the civil context real quick to get the famed Sullivan case and its requirement of actual malice for servile, defamation, and libel torts. This is important because we will see it traverse shortly to the criminal context. Here are the basic Sullivan facts for you, and we are going to listen in briefly to part of the oral argument. First, the facts. This is a quote from the opinion. Quote, "Respondent's complaint alleged that he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960, entitled, quote, 'Heed Their Rising Voices,' end quote. The advertisement began by stating that, quote, 'As the whole world knows by now, thousands of Southern Negro students are engaged in widespread nonviolent demonstrations in positive affirmation of the right to live in human dignity, as guaranteed by the U.S. Constitution and the Bill of Rights,' end quote. It went on to charge that, quote, 'In their efforts to uphold these guarantees, they are being met by an unprecedented wave of terror by those who would deny and negate that document which the whole world looks upon as setting the pattern for modern freedom,' end quote. So there you have the underlying facts, and Public Safety Commissioner Sullivan was unhappy and so sued the New York Times and Dr. King and others for allegedly making such statements against him. Sullivan won a $500,000 verdict, and so now Dr. King, the New York Times, were unhappy and challenged the verdict. This brings us to the Supreme Court in 1964. Let's now listen in a bit on part of the oral argument so you can see the issues being framed as they relate to our libel law today.
Judge Pierce and I represent the four individual petitioners in this case, which is a companion case to the one that was argued yesterday. And if the court will permit us, we would like to divide our time as far as the argument is concerned. The courts of Alabama have decreed that these four individual petitioners, too, should be punished in a civil libel action. No actual or special damages were awarded. The trial court, in charging the jury, merely said that punitive damages mean such damages as are given as a kind of punishment to a defendant with a view to preventing similar wrongs in the future, and that falsity and malice are presumed. The jury responded by awarding a $500,000 punitive damages against these individual petitioners, which was the largest such judgment in the history of Alabama up to that time. I think it may... I'm not sure. That certainly in this case, there was no precise recital. I think it's interesting in that connection, Your Honor, that the largest fine that could have been imposed in a criminal libel action in the state of Alabama would have been $500. Now, what did What did these petitioners do to deserve this punishment? A precise recital of the evidence brings into sharp focus how the petitioners' constitutional rights have been violated. The petitioners are not, in truth, being punished for what they did or failed to do in this case, but for what they said and did elsewhere, and who they are. The central fact of this case is that they are being drastically punished because they were Negroes residing in Alabama who've had the courage to speak out in the struggle to achieve the rights guaranteed by the Constitution for all citizens regardless of race or color. Indeed, these petitioners, Dr. King and these four petitioners, are the leaders of the civil rights movement in Alabama. What was the proof in the case? In the testimony offered by the plaintiff, there were only two brief references to the petitioners. The first was that their names appeared in the advertisement as published by the New York Times on March 29, 1960. The second was that a few days before this suit was started, each received identical letters from the plaintiff demanding that they publish a retraction. There was no evidence that the petitioners authorized the use of their names in the advertisement. There was no evidence that they were members of the group or committee that inserted the advertisement in the paper. And there was no evidence that they had any knowledge of the advertisement at all that appeared in the New York Times. That's all there was to the plaintiff's case. No other evidence. The defendants then proceeded to show that the total failure of proof by the plaintiff was not a mere oversight. Mr. John Murray, who was a volunteer worker for the committee to defend Martin Luther King in the struggle for freedom in the South, testified that on or about March 25th, 1960, he took the draft of the advertisement in question to the New York Times and gave it to a Mr. Aronson, who was an employee of the paper. All of the petitioners testified. Each is a spiritual and religious leader of his people. All have been active in the cause of civil rights. Each testified, though, that he had not been and was not a member of the committee to defend Martin Luther King. None authorized publication of the advertisement that appeared in the New York Times or had any knowledge of the advertisement prior to its publication. The cross-examination was brief, and nothing was developed to cast any doubt on the accuracy of the testimony of these petitioners. Why then, it might be asked, was such harsh punishment imposed? It is stated that it is because the petitioners somehow ratified the publication of the advertisement.
So there you have it on the civil side of the argument, and now we are in, of course, the 1960s. How did the Supreme Court rule? It matters because it will come back to us as we continue with the criminal libel exploration. This case held that there are levels of protection for speech against people, depending on the type of speech and the category of person the speech is directed towards. For public officials and public figures or matters of public concern, one must demonstrate actual malice to find liability when attempting to prove defamation or libel. Actual malice means the speaker made their statement with actual knowledge of its falsity, or was reckless in regard to the truth of the speech. The plaintiff must be a public official or running for public office. The plaintiff must prove his or her case with clear and convincing evidence. The plaintiff must prove falsity of the statement. And the plaintiff must prove actual malice, that is, that the defendant knew the statement was false or was reckless in regards to its falsity. Remember Sullivan sued the New York Times and Dr. King for libel when it wrote he mistreated protesters. He prevailed with a judgment, but it was reversed because he was a public figure and no showing of actual malice had been made. Bottom line, the oral argument we heard won the day. There was no basis to sue Dr. King or the New York Times, and the First Amendment protected them. Actual malice was required to justify a verdict of that kind for libel. This is the case, then, where actual malice as a prerequisite for libel against public officials and public figures first emerged. Will this idea survive? Justice Thomas has dissented regularly, arguing that Sullivan is unconstitutional, and we will come back to his ideas in a little while, so stay tuned there. Now let's pivot back then from Sullivan to the Supreme Court the same year of 1964, only several months after Sullivan, to see how they addressed criminal libel. Garrison v. Louisiana, reported at 379 U.S. at page 64. And yes, that is our prosecutor Garrison formed the JFK movie in real life, the district attorney who indicted Clay Shaw in the late 1960s for being part of an alleged conspiracy to kill President Kennedy. It turns out he made an earlier appearance at the Supreme Court in this criminal libel arena. He was certainly larger and perhaps louder than life, and so it is no shock he was publicly loud and critical about judges when he was a district attorney. Let's look at our facts of this case then. During a dispute with certain state court judges of his parish, Garrison accused them at a press conference of laziness and inefficiency, and of hampering his efforts to enforce the vice laws. A state court convicted him of violating the Louisiana criminal defamation statute, which, in the context of criticism of official conduct, includes punishment for true statements made with actual malice in the sense of ill will, as well as false statements if made with ill will, or without reasonable belief that they were true. The state Supreme Court affirmed the conviction, holding that the statute did not unconstitutionally abridge appellants' rights of free expression. Let's look specifically at what Garrison said. Quote, "The judges have now made it eloquently clear where their sympathies lie in regard to aggressive vice investigations by refusing to authorize use of the DA's funds to pay for the cost of closing down the Canal Street clip joints. This raises interesting questions about the racketeer influences on our 8 vacation-minded judges." End quote. He was convicted, got a $1,000 fine and 4 months in jail if he failed to pay. He took his case to the United States Supreme Court, which took the appeal. Let's start by listening to part of his lawyer's oral argument in 1964.
Of course, as I was just starting to say, perhaps indirectly in that connection, that we do take the position that the application of a state criminal libel statute, especially when employed as a sedition law with regard to criticism of public officials, simply can't be reconciled at all with the principles of the First Amendment passing through the 14th with regard to a state statute. There seems to have been considerable controversy on that subject in this court. I don't have to go all the way with the proponents of that principle, whatever my own views are, but in this particular case, you've got a general criminal libel statute being applied as a sedition. Now, of course...
You're limiting this now. This argument limited to public officials?
That's as far as I have to go.
That's right. But is your argument based that this is a sedition law?
That this is being applied as a sedition.
Because it involves...
criticism of public officials. That's right.
But in their official capacity?
Well, of course, the argument is made on the other side.
So you heard there Justice Brennan asking a few questions of the lawyer who mounted the argument on behalf of District Attorney Garrison. And here is what the Supreme Court then held. At the outset, we must decide whether, in view of the differing history and purposes of criminal libel, the New York Times rule also limits state power to impose criminal sanctions for criticism of the official conduct of public officials. We hold that it does. Where criticism of public officials is concerned, we see no merit in the argument that criminal libel statutes serve interests distinct from those secured by civil libel laws, and therefore should not be subject to the same limitations. At common law, truth was no defense to criminal libel. Although the victim of a true but defamatory publication might not have been unjustly damaged in reputation by the libel, the speaker was still punishable, since the remedy was designed to avert the possibility that the utterance would provoke an enraged victim to a breach of peace. The statute can only criminalize statements that are knowingly false or made with a reckless disregard for their truth or falsity. Based on this standard, the Louisiana criminal defamation statute was held unconstitutionally broad and infringes on the First Amendment. So again, we have a curtailment of scope of criminal libel statutes, but not an outright abrogation. The actual malice standard must apply. There it did not, so Garrison did not go to jail. But one could go to jail theoretically if actual malice is shown and there is no truth defense. Let's do a quick fun sidebar on Garrison since he was in the famed JFK movie. And if you want a deep dive on JFK and Ruby, I have 2 programs, one on JFK law that looks at the assassination and other JFK law issues, and one on Jack Ruby and his trial for killing Oswald. And both have law as it relates to Oswald and the presidential release of records. Back to Garrison. He lost his trial to prove a conspiracy, and Owen key witness was a guy named Russo. Russo said to newspapers that Ferry said to him they were going to kill JFK and never heard of Oswald. But Russo said to Garrison that a person he saw with Ferry was Oswald. Garrison hypnotized Russo via sodium pentothal, who then said that Ferry, Shaw, and Oswald discussed killing JFK. Garrison also gave him a polygraph, but he failed. Garrison used him at trial nonetheless. Post-trial, Garrison charged Shaw with perjury depending upon Russo's purported testimony. Shaw challenged the second charge in a federal civil rights action. The district court held a 3-day hearing where Russo now asserted the fifth, and quashed the prosecution as a vexatious campaign. The court said the perjury charge was brought in bad faith and for purposes of harassment. Garrison appealed. This time his appeal did not go so well. The Fifth Circuit held that the extreme measures the state resorted to in extracting information from Perry Raymond Russo and the use of his testimony at the trial were incompatible with the American system of justice. The state's case against Shaw for conspiracy to assassinate President Kennedy turned on the testimony of Perry Russo. No one knew better than Garrison how unreliable Russo was. If he had ever any faith in Russo's credibility, it must have vanished when he heard Russo testify. Russo was equally important in the state's case against Shaw for perjury, and any hope of winning that case vanished when Russo, asserting his Fifth Amendment privilege, declined to answer any questions when put on the stand in the trial in the district court. In view of the extreme lengths Garrison went in the first place to persuade Russo to corroborate the alleged conspiracy theory, it is a fair inference that he knew Russo would be as ineffective in the second trial as he was in the first. Moreover, considering also the extreme lengths to which Garrison went for the purpose of proving his case, it is a fair inference that he well knew that Russo would take the fifth. More brutally, there was no basis for Garrison's initial interrogation of Shaw. The Supremes didn't take Garrison's appeal this time. Let's pivot back to criminal libel in the 1960s again. Our next case is Ashton versus Kentucky, and this picks up on Garrison from 1964 as the Supreme Court continues to struggle with criminal libel. There, petitioner was sentenced to 6 months in prison and fined $3,000 for printing a pamphlet found to be prohibited by the common law of criminal libel in Kentucky. His speech was a pamphlet about the chief of police. He said, quote, 6 weeks ago, I witnessed a plot to kill the one pro-strike city policeman on the hazard force. 3 of the other cops were after him while he was on night duty. It took 5 pickets guarding him all night long to keep him from getting killed, but they could not prevent him from being fired, which he was 3 weeks ago. Another note on the city police. The chief of the force, Bud Luttrell, has a job on the side of guarding an operator's home for $100 a week. It's against the law for a peace officer to take private jobs. Let's first listen to some of the criminal libel oral argument at the Supreme Court, and then we will get back to the ruling.
Mr. London, you feel that Kentucky has no constitutional power to make statements like that a crime under Garrison?
I think it has not, Your Honor. I think that the law is, as I understand it, if the doctrine still has any validity, that one cannot make any writing or speech or communication criminal unless it presents some serious danger to the community. And as I understand the Garrison case, I understand it to mean that a libel must somehow seriously disturb the security of the community before it may be punished as a crime.
In my state, a man was convicted for a criminal libel for calling George Washington a rascal.
Yes, Your Honor, and that conviction was some 200 years after George Washington's death.
Just about, yeah.
Are there any statutes at all that make libel a crime?
In Kentucky?
Yes.
No, Your Honor, I think there's a statute relating to slander, but this is a common law offense.
Have there ever been any statutes that made libel a crime?
In Kentucky, I believe not, Your Honor. I believe the first case came about 1888, in which they suddenly punished someone.
That was the court.
Yes, Your Honor.
The legislative body has never made it a crime.
No, Your Honor, the legislative body never did, although I suppose it recognized the existence of this as a common law crime in providing for general punishment under a statute, limiting the punishment to a year and $5,000 fine.
There are a good many common law crimes in Kentucky.
Yes, Your Honor.
Aren't there?
Yes, Your Honor.
Unlike some states where all the criminal law is statutory, there are a good many. In Kentucky, there remain a good many common law crimes.
From my little knowledge of Kentucky law, I think the majority of crimes there are common law crimes.
Yeah.
Now, the Attorney General of Kentucky concedes that very trifling personal abuse can be punished as a crime in Kentucky. But he says that's not an objection to the law because the jury, although it can imprison a man for a year for this trifling insult and can fine him for $5,000, may also impose a very small punishment, even of $1 fine, and make the punishment fit the crime.
So there we heard the complexity of criminal libel as a common law crime without clear statutory metes and bounds. Let's see how the ruling came down now. The court held Kentucky's common law crime of libel was too indefinite. Any writing calculated to create disturbances of the peace, corrupt the public morals, or lead to any act, which, when done, is indictable. This holding essentially guts all common law criminal libel prosecutions. Quote, since the English common law of criminal libel is inconsistent with constitutional provisions, and since no Kentucky case has redefined the crime in understandable terms, and since the law must be made on a case-to-case basis, the elements of the crime are so indefinite and uncertain that it should not be enforced as a penal offense in Kentucky. End quote. This gets us to where we stand today, basically. Criminal libel to survive at all must be 1. Statutory. 2. With no limits on truth as a defense. And 3. Actual malice must be shown for a conviction for statements about public officials or public figures. Now let's go to Kansas in 2002. Here we have a criminal defamation conviction against a newspaper and its editor. An article reported a rumor that Mayor Carol Marinovich and her husband, a judge, did not reside, as required by law, in the county where they hold office. DA indicted the reporters and papers. Kansas law made it a crime to communicate information tending to expose another living person to public hatred, contempt, or ridicule, or tending to deprive such person of the benefits of public confidence and social acceptance, provided that the speaker knows that the information is false or acts with actual malice. The jury convicted and fines and probation were issued as sentences. From Kansas, we now travel to Utah. This is the case of Utah versus Lake. There, Beaver County, Utah deputies arrested the 16-year-old Milford High School student. Lake was charged with 1 count of criminal libel under a Utah code, and 1 count of criminal slander for imputing unchastity to a female in violation of Utah Code, Section 76-9-507, after posting derogatory comments on a website. Lake referred to several students' sexual history and also accused his high school principal of being the town drunk and having an affair with the school secretary. Utah's criminal libel statute states that a person is guilty of libel if he intentionally and with a malicious intent to injure another publishes or procures to be published any libel. The crime, a misdemeanor, carries a penalty of 6 months in jail and a $1,000 fine. Lake, as a minor, spent 7 days in a juvenile detention facility. The state later dropped the slander charge but continued to pursue a libel conviction. Defendant's motion to dismiss was denied, but the Utah Supreme Court takes the case. And there you have the reported decision at 61 Pacific 3rd page 1038 from 2002. The Utah Supreme Court held the law unconstitutional. It held the plain language of Utah's statute does not comport with the requirements laid down by the United States Supreme Court. First, the statute does not punish only actual malice when the statement concerns public officials. The statute punishes all statements made maliciously, but the common law definition of malice is quite different from the actual malice contemplated by the United States Supreme Court. And it further held, the statute provides no immunity for truthful statements. As a result, the bottom line was, quote, "We hold that Utah's criminal libel statute infringes upon a substantial amount of constitutionally protected speech by punishing false statements regarding public figures made without knowledge or recklessness, and true statements regarding public figures. The statute is therefore overbroad and unconstitutional." End quote. Let's look at the Craigslist case from New Hampshire now. This made its way to the First Circuit in 2022. The New Hampshire state law at issue states that, quote, "A person is guilty of a Class B misdemeanor if he purposely communicates to any person, orally or in writing, any information which he knows to be false, and knows will tend to expose any other living person to public hatred, contempt, or ridicule." End quote. Wow, just pause on that. This is the state whose motto is live free or die. I guess they don't mean speak free. Let's keep going, though. The fact pattern was as follows. Hudson Police Department arrested defendant Freese for comments about a local life coach that he posted on a Craigslist website. Defendant called the coach's business a scam and accused him of, among other things, being involved in a road rage incident and distributing heroin. Without the advice of counsel, defendant pleaded guilty and was fined $1,488, of which $1,116 was conditionally suspended. 6 years later, the Exeter Police Department arrested defendant for comments he had pseudonymously posted in the online comments section of a newspaper article about a retiring Exeter police officer. The comments included statements that the retiring officer was the dirtiest, most corrupt cop defendant had ever had the displeasure of knowing, and that the officer's daughter was a prostitute. Okay, pretty brutal comments for sure. Let's see what the First Circuit did with it. Defendant argued that Section 644.11 violates the First Amendment because criminal defamation laws should be per se unconstitutional. But the Supreme Court, however, has upheld the criminalizing of false speech, explaining that deliberate and recklessly false speech does not enjoy constitutional protection. There, the First Circuit cited back to our Garrison case. Thus, the state can impose criminal sanctions for criticism of the official conduct of public officials, so long as the statements were made with actual malice. That is, with knowledge that they were false or with reckless disregard of whether they were false or not. What this means, then, is this statute met constitutional muster as a narrow one within the fit of the First Amendment and the Sullivan-Garrison test, with the added right to truth as a defense. The statute is not unconstitutional, that is. There was a large push to get the Supreme Court to take the appeal, but it declined. So it seems there is the fixed status of our criminal libel law as it currently stands, at least from the Supreme Court crafting the First Amendment's contours onto the scope of liability. Here is a map of states that criminalize libel versus those that do not. The majority do not, as you can see. It's a fascinating map, I think, and I do not think it neatly lines up with our red-blue electoral college maps from recent elections either. So if you live in the orange-colored states on this map, be more careful with your statements. Facebook, X, and Twitter all make saying all manner of things easy and fast, as we see every day. But it also turns our prosecutors in those states have the power to seek criminal libel charges too. Be careful in light of this is my basic advice and practice pointer. Let's take a look at an Oklahoma law as it relates to criminal libel risk. This is Criminal Statute 21, 977, and it makes it a criminal offense to question a woman's chastity. The law says, quote, "If any person shall orally or otherwise, falsely and maliciously or falsely and wantonly impute to any female, married or unmarried, a want of chastity, he shall be deemed guilty of slander, and upon conviction shall be fined not less than $25 nor more than $500, or by imprisonment in the county jail not less than 30 days nor more than 90 days, or by both such fine and imprisonment." End quote. Fascinating. Be super careful in that state then on that issue. Other states have similar laws too. It does not appear that they actually get invoked. For if they did, there would be no doubt all manner of First Amendment challenges, among others. Remember I told you we would look again at the Sullivan Rule and Justice Thomas's critique? Well, now is the time. Justice Thomas has long written that when the Supreme Court got the Sullivan case, it was a policy-driven decision that imposed this actual malice idea into the law and required this higher showing if a plaintiff is a public figure and wants to sue for defamation. Here is what Justice Thomas has written. Quote, "The common law of libel at the time the First and 14th Amendments were ratified did not require public figures to satisfy any kind of heightened liability standard as a condition of recovering damages. To be sure, the law was not static. In the first decades after the adoption of the Constitution, the rule that truth or good motives was no defense to libel was changed by judicial decision, statute, or constitution in most states. But from the founding until 1964, the law of defamation was almost exclusively the business of state courts and legislatures." End quote. That was a concurrence he wrote in Blankenship versus NBC Universal in 2023. As it stands, however, Justice Thomas has not received official support from fellow justices to take this issue on. But stay tuned to see what happens in coming years, as this question is not a dead one. This brings us to the end of our program today. Let's do a quick recap of our conclusions. The Sedition Act was highly controversial at Republic's founding, but stood at the time and was not seen as antithetical to the First Amendment then. And as we saw, criminal libel history is one of narrowing laws and their potency by the Supreme Court, but not outright eliminating criminal libel. While most states have abandoned criminal libel, many states still have laws on books, so be extra careful in those states. Prosecutions are rare, but they do happen and can withstand constitutional muster, as we saw in recent cases in various states, even reaching the First Circuit. Supreme Court case law tracing shows a huge narrowing of scope of state criminal libel laws to the root that is now required for them to stand. Specifically, actual malice is required without any limits to the right to assert truth as a defense. Now, live free or die is the New Hampshire motto, but as we saw here, the live-free state will get you for criminal libel if you cross a boundary. The best course of action, then, is to remember that criminal libel is alive and well in many states, even if it has been narrowed by Supreme Court First Amendment jurisprudence. We had a few fun sidebars that allowed us to explore Garrison when he pushed too hard as a prosecutor in what we would call a weaponized prosecution today, as well as the weaponized imprisonment for speech that befell Harry Bridges, which was brutally condemned by the Ninth Circuit. And of course, we will wait to see if Justice Thomas prevails over his fellow justices to get the Sullivan actual malice standard reversed. If he does get that done at some point, then our Garrison case would necessarily be revisited, and it would fall too. This would mean that it would be easier for states to punish libel criminally, which, given the sheer amount of extreme speech we see every day on the internet, and zealous prosecutors, probably means we would see an uptick in criminal libel prosecutions if Sullivan and Garrison were to be reversed. Best practice tip: don't libel, slander, or defame people. Even though it is so easy to issue statements into the hyperbolic world of internet social media communication, there is real criminal exposure in multiple states, let alone civil liability. Stay curious and stay on the safe side of the law. And as ever, if you have questions, please email me. Thank you, and have a wonderful day.